petitioners are not involved in this case because petitioner number one is a sister, number two nephew, and number three brother of the main culprit lordship. That is,
Let us say they come finally will dispose of on Monday.
if possible, lordship, some sort of interim possible lordship.
Manu, who is Manuara Begum?
She's a sister of Abdul Patel, that is the husband of the women lordship.
Husband of the foreigner.
Foreigner, yes.
And Abdul Ahad
He's a
is
nephew.
nephew.
Yeah. And number three is the brother, elder brother.
Number three is
Elder brother. And
no allegation
Was-
regarding this
forgery lordship. The effects of
preparation of this fake documents against whom? These three persons.
no, only the Abdul Patel Choudhury, that is husband.
Where is the FIR?
FIR is page 11, and at page 12, you lordship will find that during inquiry, it is revealed that
What is page number 16? Page number 16 is lost by you.
yes, lordship. It is lost by us, lordship.
Heard Mr.
Okay, sir.
Learned counsel for the applicant and also heard Ms. A. Begum, learned additional applicant for the respondent. Pending arrest in connection with Morazar PS case number
11.
11 of 2024 under section 120B 419 468 471. Read with section 14 of the Foreigners Act. This application under section 438 services prepared by three applicants, namely Manuara Begum, Abdul Ahad, and Abdul Mokid, for grant of arrest pay. The above noted case has been registered on the basis of an FIR lodged by SI, which in bracket B, Ishfaqul Haq, on 24/1/2024. The allegation level against the essence of allegation made in the affair dated so and so is that one Abdul Batin Chaudhary of Shibpur number 2 under Murazar PS is Harvard one Reena Akhtar, a Bangladeshi national, and manage and obtain force manipulated document such as PIN card, Aadhaar card, etc. Birth certificate, school certificate, bank account, voter ID card, etc. Mr. Sharma Learned Counsel for the applicant submits that applicant number 1 is the sister-in-law
Sister-in-law,
of the
victim.
Abdul Batin.
This is sister also,
Sister-in-law Abdul Batin.
not sister-in-law, sister, elder sister.
Sister is the elder sister of Abdul Batin. Abdul Batin.
Totally.
Abdul Batin Chaudhary, and
Number 2 is the
applicant
nephew.
number 2 Abdul Ahad is the nephew,
Nephew.
and applicant number 3 Abdul Mukit
Elder brother.
is the elder brother of the accused Abdul Batin, and they are no way involved with the offense alleged in the affair, and they are ready to cooperate with the investigating agency, and therefore it is contended to allow the petition. On the other hand, Ms. E. Begum learned additional PP submits that at this instance only CD may be called for. Where having heard the submission of learned advocates of both sides, it is provided that CD be called for fixing Monday. As it is submitted at the bar that another bail application being
Another bail application number 330, 320.
BA or AB?
AB, order,
AB, another AB being number
320, sorry, 320.
is fixed on Monday, and in connection with the said AB, the case diary has already been called for, and this petition may be tagged with the said petition, and case diary may be perused to dispose of the may be perused on that day to dispose of the present application also. Accordingly, it is provided that registry shall take the AB number so and so with the present application, and on that day CD will be perused to dispose of the present application also. And in the interim, considering the submission of learned advocates of both sides, and also considering the nature and gravity of the offense against the present applicants, this court is inclined to extend interim protection to them till receipt of the case area, and accordingly it is provided that in the event of arrest of the applicant in connection with Murazar PS case number so and so under section so and so, they shall be released on interim period as bail on their executing a bond of rupees 50,000 each with 1 surety of like amount to the satisfaction of the arrest authority. Above privilege is also subject to the following 3 conditions. Last condition, they shall not leave the jurisdiction of CJM Hosai without prior permission.
Deeply applied.
Item number 58, 59, upgraded matters.
May I please, Your Lordship? Chief, this is a criminal appeal matter, Your Lordship. And we are challenging the judgment and order passed by the learned special judge wildlife guardian on Gifu, Your Lordship. Lordship, the brief facts is that the prosecution case is that I was found to be in possession, and further I was transporting wild captive animals that are protected under the Wildlife Protection Act, and they are Schedule 1 animals. This is the offense which I have been alleged to have been committed. Lordship may kindly find the offense at page 43, Your Lordship. If Your Lordship may kindly take page 43. Lordship, there is a heading on the top. It says nature of the offense. Nature of the offense, Your Lordship. May I read it, Your Lordship?
Yes.
Connection with possession of scheduled animal article, that is 1 gibbon species and 4 primate species under the family Serpopithecidae, which is listed under Schedule 1, Part 1 in Wildlife Protection Act 1972. So the allegation is that I have committed the offense of being in possession of 1 gibbon and 4 primate species that are part of Schedule 1, Part 1 of the Wildlife Protection Act 1972. And your lordship, if your lordship may kindly come to page 6 of my appeal, page 6. That's it. Page 6, your lordship. I've just listed down the 5 animals that have been alleged to have been recovered from my possession. So these are the 5 animals, your lordship. Lordship has found page number 6.
Page 6 is the judgment.
Page 6 of the appeal, your lordship. Appeal number 416 of 22.
No, you have enclosed the judgment of the court below after the synopsis.
There's some error in that case, your lordship.
Pardon?
I think there's some error in that copy.
Is it 416 criminal appeal number?
Yes, your lordship. Lordship, can you take 417? It's the same thing. Maybe there it is not corrected.
Yes, page number 6, paragraph number 9.
Yes, your lordship. Lordship, this is the list of the animals that have been alleged to have been recovered. Number 1, Siamang gibbon. Number 2, crested black macaw, adult female. Number 3 is crested black macaw, adult male. 4th is Celebes crested macaw, and 5th is moor macaw. So these are the 5 animals that are alleged to have been recovered from my possession. Now, your lordship, my simple and humble submission before lordship is that these 5 animals are not part of Schedule 1 of the Wildlife Protection Act. As such, your lordship, no offense has been committed under the Wildlife Protection Act. And this entire prosecution case is bad in law, your lordship.
Yes, Mr. Gogoi.
If he has some additional to submit, I'll submit finally, not on piecemeal, my lord. If he has some other grounds. If he has some other grounds, he may urge, my lord.
Lordship,
If that is the sole
this
ground,
is,
I can answer, but if he comes with additional, let him complete his whole, my lord, as a whole, my lord. I'll reply to
lordship, this
finally.
is the one point on which the entire prosecution case fails.
No, no, tomorrow বেলেগ থাকিব পাৰে। Defense tomorrow থাকিব বেলেগ। Sorry.
Okay, lordship, as he wishes, your lordship. So, your lordship, then your lordship may kindly come to page 15, your lordship. Page 15 of the appeal, your lordship. Your lordship, I
Page
take page
15.
15 of the appeal, your lordship, at para 18. Lordship, this page para 18, I have noted down the statement of the seizure witness. The seizure witness, your lordship, PW5. May I read it, your lordship?
Yes.
PW5, the seizure witness deposed that he runs a pawn shop near the Delhi Gate. Delhi Gate is the place of occurrence where I have been arrested. He did not know the complainant PW3. He knew PW7 who had seized the materials on the day of occurrence. He deposed that occurrence took place at about 5:30 to 6 p.m. He saw the police recovered 5 numbers of monkeys which were kept in 5 numbers of plastic boxes from a van. In his cross-examination, now your lordship, in his cross-examination, what he states? He stated that he did not remember the registration number of the vehicle, nor did he remember the color of the van. So the vehicle is not identified by the seizure witness. He saw the 5 monkeys kept on the ground near the van, and he did not see the 5 monkeys inside the van. So he even didn't witness the seizure. The seizure event was not witnessed by him. He was just a witness who had just signed it. He also stated that he did not know from where the police recovered the monkeys and from whose possession the monkeys were recovered.
Yes.
Lordship may then kindly.
So no other Caesar witnesses are there?
No, Your Lordship, only one.
He is the only Caesar
He is
witness.
the only independent Caesar witness. Rest are the police persons.
So why should we disbelieve the police personnel?
Lordship, this independent Caesar witness was brought in by them and stating that he is
No,
the
that's all
independent.
right. He may not know from whose position the monkeys were recovered.
Yes, Your
But
Lordship.
why should we disbelieve the police personnel? Is there any law that evidence of police personnel should be disbelieved?
Lordship, I'll satisfy Your Lordship. This entire event that happened,
Hmm.
it is a conspiracy against the petitioner, Your Lordship, against the appellant, Your Lordship.
Conspiracy?
Against the,
Why? What kind of conspiracy?
so that he is arrested on this grounds.
On
Because the-
why? Why?
Lordship, what I submit, Your Lordship, that the animals were not recovered from my possession.
Hmm.
I was on my way from Manipur to Guwahati when I was just grabbed by them, and then they have placed all these things in my prion.
Hmm.
So this is my submission, Your Lordship.
Hmm. Why you have been implicated here in this case falsely? Do you have any enmity with the police personnel?
One of the main appellant, Habibur, Your Lordship, he is a police personnel in Manipur. He is a police personnel in Manipur. There is some enmity, Your Lordship.
With?
With this, the PWs, the police personnel who have registered this case against him, who have complained against him,
So he is a police personnel from Manipur.
Manipur. And there is some enmity in some case before. So that is the reason when they got a chance, he was coming from Manipur along with his driver, then they had grabbed him.
You furnish the case number?
Yes, Your Lordship, that can be done.
You furnish the case number. You have to establish it.
Yes. No, my lord, what happened, my lord? That was a query from the court, my lord.
Come this side. Come this side.
Now, my lord, what happened, my lord? These things, my lord, these enmity grounds and everything, my lord, unfortunately have not been brought in the evidence in the learned trial court, my lord.
Hmm.
So, my lord, we will not submit that, my lord.
Hmm.
In the trial court, my lord, whatever this appellant has stated to us, he have stated to the counsels at the trial court also, but that has not been brought in the record. And since that is not on record, that enmity part,
Hmm.
we will not rely on that. We will not submit on that.
Hmm.
But our submission is that whether these are scheduled animals or not,
Hmm.
if these are scheduled animals, then this conviction will be there.
Hmm.
If these are not scheduled animals, my lord,
Hmm.
then they are liable to be acquitted, my lord.
Hmm.
So, my lord, my learned friend is placing the judgments, my lord. There is a judgment of the Honorable Supreme Court also, where the Honorable Supreme Court has specifically stated that if these are not scheduled animals, then the conviction cannot stay.
Hmm.
Yes. My lord, he'll place it, my lord.
So, Lordship, mainly we are on this only one aspect that whether they are schedule one animals or not.
Hmm.
Other aspects are there, but the most strongest aspect is whether it is a schedule animals. And now this is a judgment of the Honorable Supreme Court of the Division Bench, Honorable Division Bench of the Supreme Court in 2021.
Hmm.
Herein the facts are exactly similar to this case, Your Lordship. So the difference is that instead of monkey, here it is a turtle. Lordship, I will, if your
This is
Lordship,
the relevant paragraph.
relevant paragraph, page number 813, the second page, page 813 on the left hand side page, Your Lordship, para number 5.
Yes.
The respondent, may I read, Your Lordship?
Hmm. Yes.
The respondent accused filed an application before the High Court for quashing the criminal proceedings. It was submitted before the High Court that Indian flapshell turtle, which was seized, was not found included in Part 2 of Schedule 1 to the Wildlife Protection Act 1972. Hence, such possession of the turtle of that species will not invite the offences alleged against the accused. Same submission we are making, Your Lordship, in this case. Now, the High Court, being satisfied that the turtle seized was not that species of turtle which is included in Part 2 of Schedule 1 of the 1972 Act, allowed the application and quashed the criminal proceedings. It was a 4T2 application and the entire proceedings was quashed just because it was not a Schedule 1 animal. And the Honorable Supreme Court upheld it. Your Lordship may kindly take para 13. Last page, Your Lordship. Para 13. May I read
Yes.
it, Your Lordship? A perusal of the letter given by here, Your Lordship.
Hmm.
One important, I'll just try to bring to the notice of this Honorable Court. In this case that I'm placing, here a surgeon was appointed to identify the species. In our case, there is no such official witness, zoological witness to identify the species. It's only the forest officials. Your Lordship, I'll read. A perusal of the letter given by the veterinary surgeon as extracted above indicates that the veterinary surgeon has identified the turtle as Indian flapcell, within bracket, Lysimys punctata. This is the scientific name, Your Lordship. Whereas the turtle which is included in Part 2, Schedule 1 of 1972 Act is Indian soft shell turtle, Lysimys punctata punctata. Lysimys punctata is a species of which Lysimys punctata is infraspecies. Here it was the infraspecies. However, the turtle which has been seized is not that which is included in Part 2 of Schedule 1. In the facts of the present case, on the face of it, the turtle seized is not included in Schedule 1, Part 2, and the turtle having already been freed on the second day of the seizure, the High Court did not commit any error in quashing the criminal proceedings registered for wildlife offences. So, Your Lordship, here the Honorable Supreme Court upheld that if it is not a scheduled animal, no offence has been committed under the Wildlife Protection Act, Your Lordship. And Your Lordship, in my appeal, how the learned special judge came to the conclusion whether these are Schedule 1 animals. Your Lordship may kindly come to the judgment, the impugned judgment, which is at page 53, Your Lordship. Impugned judgment starts at page 53. I would like to take your Lordship to
Paragraph number?
paragraph number 38, Your Lordship.
Yes.
Lordship, may I read it, Your Lordship? It is reiterated that the Forest Department witnesses have supported one another and thus fortified the prosecution version that animals seized were actually primates and gibbons, and on this material point, there is no variation or discrepancy. There is also no cross-examination on this aspect. In that view of the matter, even dehorsed the examination of a zoologist. Zoologist was not examined, Your Lordship. I believe these forest officials that the animals seized were the ones included in Schedule 1 of the Special Act.
Okay.
There is no evidence or no zoological examination of an expert zoological expert to the effect that these are in fact Schedule 1 animals. Only the forest officials stated in their examination in chief that these are Schedule 1 animals. It was believed by the learned special judge below. And Your Lordship, just on the basis of belief, conviction can't be upheld, Your Lordship. Lordship, then may kindly come to para 46, Your Lordship.
No, the court below has believed the forest officer.
Para forest officials. They say forest officials stated these are Schedule 1 animals. Learned judge believed.
But you cannot find out which number is serial number.
But Your Lordship, the schedule has a number of species, number of animals listed out there. At least which number of the animals? What is the serial number of the animal that has been
No,
recovered?
did you cross-examine the witnesses on that point? Before the trial court?
My lord. There is one thing, my lord, on the part of cross examination also, my lord. I have gone through the record, my lord.
Hmm.
What happened, my lord? Witnesses are not coming and saying that these are this serial number of the Schedule 1 animal.
Hmm.
So when the witnesses don't state
Hmm.
that which animal of Schedule 1,
No, Mr. Khan, you see, the court below has observed that the witnesses have testified that they are Schedule 1 species. And the court below has believed them.
no, my lord, witnesses can go to the arrest police. What question Schedule 1? I'll go through once, my lord, quickly.
Mm.
No,
Well, they have not annexed these scissor witnesses. The,
No, no, Mr. Gogoi, you can go through the record.
I have to go through LCR because, my lords, Wildlife Act, my lord,
Hmm.
section 50, subsection 8, my lord, it is at par with 164. It is at par with 164. And also, my lord, section 57, my lord, presumption is on the other side, my lord. The accused has to prove that he is innocent. Section 57, and my lords, I have to peruse the LCR also.
Witnesses, my lord, I have gone through, my lord.
Mm.
Witnesses, they are nowhere stating that these are schedule 1 animals. It is as per the seizure list.
Mm.
Offense report. Witnesses don't come and say that these are schedule 1 animal or like that specific, nothing specific is there.
But that is in the offense report.
Offense report. And my lord, it is the duty of the prosecution
Mm.
to prove that
No, no.
these are scheduled animal.
No,
They cannot
no,
bring in any
no,
animal and say that these are scheduled
No.
animal, and then we have to prove that these
No.
are not scheduled animal.
My lord, section 57 for a moment, my lords, Wildlife Act. Presumption to be made in certain cases. Presumption is all.
No,
the
no,
other
Mr. Gogoi, that presumption is there, but it
I can prove, my
doesn't
lord.
relieve
Within, my
him
lords,
from
my lord, they've got it.
establishing the case
lord,
beyond reasonable doubt.
But a question is that
Mm.
the pertinent question, the whole foundation of this case, that
Mm.
these animals, whatever they possess, my lord, is not within the wildlife schedule, be it wildlife schedule 1, be it wildlife schedule 2, it's nowhere. This position has been agitated in this honorable court many times, my lord, wherein, my lord, this court, my lord, has held, citing a few Supreme Court rulings, my lords. These are all chimpanzees, my lords. We had also an occasion to deal with, my lords, wallabies. Wallabies are, my lords, these are small kangaroos, my lords, found in Australia. They were brought to Silchar. These was the same case, my lords, which was agitated that Titi Joseph. Whereas, my lord, this honorable court took a very different view.
In mammals, my lord, schedule 1, my lord,
Mm.
mammals, there are total
No, my
40.
lord, that I admit. Within this schedule, they are not. But
There-
I
there-
no,
there-
no,
there
no,
is
my lord, I
nothing
have
offense.
case laws. I have case
No,
laws
no,
to cite.
one by one.
I have case laws to cite. They might not be there, my lord, with a particular name, but the family is included.
So, Mr. Gogoi, you admit that they are
No,
not
my lord.
scheduled species.
They are not within this schedule. My lord, now Wildlife Act has been amended. My lord,
Hmm.
I have case laws to cite wherein, my lord, the Honorable High Court, Supreme Court says
Mm.
India being a, my lord, signatory to CITES, my lords,
Mm.
and wildlife being a these while construing, my lords, statute, my lords, the whole ambit of wildlife has to be widened, my lords. There is a three judges bench, my lords. There's a 3 judges bench, and also, my lord, 3 judges, 3 judges bench, my lord.
Mm.
And also our Honorable High Court, my lord.
The new act came into effect from 1/4/2023,
That I
my
can,
lord.
that I can,
That will not
that
apply
I
on me.
can establish, that I can say that when interpreting a statute, my lords, the wildlife comes here, my lord. These animals also comes.
1/4/2023, my lord. With effect from the new act.
Amended Act.
Yes,
No, no,
1/4.
amendment it doesn't mean, my lord. I will go by such different footing, my lord. I have a total different argument, my lord, different line of argument.
Cannot be applied retrospective.
We are not applying.
Yes,
Time language, sir.
It is hit by.
My lord, it's, my lord, it will require some time, my lord. So such a voluminous
No,
record.
no, the case is fixed today for hearing.
And I can
And
go by
his
hearing, my
instance.
lords. I can go. No, it is his instance, man. It is not. That is not. Well, this probably to fish out the statements will require some time. Apart from that, on his that single point submission that these are not animals. These are not animals in the schedule element. I'll rely on two judgments. And also our honorable court.
So, Mr. Khan, your part is over.
Almost, my lord, this is the sum and substance of our argument, my lord.
This part is over, substantially over.
Purely on legal issue, my lord.
Yes.
One of the first judgments I rely on, it's Indian Handicrafts Emporium, 2003, 7 SSG 589. Three judges bench, my lord.
Mm.
At para 27, my lords, of that judgment. Interpretation of the act, my lords.
Mm.
Shall I read out, my lords?
Yes.
The provisions of the said act must be construed having regard to the purport and objective it seeks to achieve. Not only internally, a wild animal is to be protected by all other steps which are necessary, therefore, so as to ensure ecological and environmental security of the country must be enforced. The interpretation provisions as regards wild animal employ the word includes and thus must be assigned as a broad meaning. The amending acts must be viewed in that perspective. Protection and conservation of wild animals is essential for every existence of human life. A trade in wild animal which sought to be prohibited with an object to oversee the survival of the human beings must be given its full effect. CITES, I'll pause for a moment. CITES is the international convention, when all these animals are included. CITES was formulated keeping in view the aforementioned policy. India is a member state of the convention. It is signatory to the other treaties and convention in this behalf. Appendix 1 of the CITES, which came into effect from 18/1/1980, provide for complete prohibition of internal trans-border trade in ivory. Parliament enacted the Amendment Act with a view to save the species of Indian elephant and to give effect to the same international treaties. Prior thereto, that is 1980, the African elephant was proposed to be brought in Appendix 1 of CITES. But in this case, ivory, which was an ivory of African elephant, was brought and caught. The contention was raised that since African elephant is not a part of Indian Wildlife Act, there is no case. Wherever, my lord, now, my lords, kindly come to point 34.
Yes.
In Narendra Kumar versus Union of India, this court, while interpreting the word restrictions, held as follows, my lord. It is reasonable to think that the makers of the constitution considered the word restriction to be sufficiently wide to save laws inconsistent with 19(1) or taking away the rights conferred by the state article, provided this inconsistency or taking away was reasonable in the interest of different matters mentioned in the clause. Thus, there can be no doubt whether or therefore that they intended the word restriction to include cases of prohibition also. The convention that the law prohibiting the exercise of fundamental right is in no case safe, cannot therefore be accepted. And my lords, for 41, para 41.
Yes.
41, my lords, it may be necessary to go into the history of legislation leading to enactment of the said act for the purpose of undertaking how small restrictions were replaced by with bigger ones and ultimately to total prohibition. We may notice that the first legislation, my lord, I am the interpretation of the act. I'm on the for protection of birds was enacted in 1887, known as the Wild Birds Protection Act 1887, which was followed by the Wild Birds and Animal Protection Act 1912. as the object sought to be achieved by this act was not fulfilled, the same was amended in the year so and so, my lord. The provincial government could declare any area to be a sanctuary for the birds or animals, and the killing was made unlawful. As wildlife has stayed subject to legislation in the year, several states adopted resolution in term of Article 252 of the Constitution of India, empowering the Parliament to pass the necessary law. The provisions contained in the 1972 Act are found to be inadequate, necessitating extensive amendment. One of the objects and reasons for the said act was to see that wild animals or articles or derivatives thereof may not be smuggled out to meet the demand in foreign countries, as there is hardly any market within the country. And also, my lords, also, my lord, para 44. The poaching of, at this juncture, we may usefully take notice of statement of objection reasons for the said act. Poaching of wild animals and illegal trade of products derived therefrom, together with degradation and depletion of habitats, have seriously affected wildlife population. However, hunting of wildlife in exceptional circumstances, particularly so and so, my lord. Then, my lord, that CITES, my lord, it may be recalled that parties to the CITES international trade in endangered space of wildlife and flora being greatly concerned by the declining population of African animals due to illegal trade, my lord. These CITES has been given my lord, importance more and more, my lord. So, my lord, by this, also, my lord, para 50 and 52. 53 is important, my lord. That is his case. It is therefore difficult to accept the contention of Mr. Sanghi that protection and preservation of wildlife would not be in public interest or cannot be extended to imported ivory, my lord. Exactly this case, my lord. That was imported ivory from Africa. Imported ivory. Wildlife forms a part of our cultural heritage. Animals play a vital role in maintaining ecological balance. The amendments have been brought for the purpose of saving the endangered species from extinction, as to for arresting the depletion in the numbers caused by callers' exploitation thereof. 56 is important, my lord. So in this case, my lords, ivory from African elephants were brought in. Amendment was done that anybody who does business in this ivory of African elephants would be arrested. This was challenged. The Honorable, my lord, Supreme Court said, while amending while giving a construction to the interpretation of the act, my lord, this ivory has to be, India being a signatory of CITES, my lord, has to be included. These animals has to be included. It is no, that is the case, my lord. And also, my lord, I'll come to the another judgment. It's Balram Kumawat. Balram Kumawat also have 3 judges bench. Para 25. As 25, a statute must be construed as a workable instrument. My lord, para 25.
Yes.
My lord, a statute must be construed as a workable instrument. Would this, my lord, let it make sense. In Tinsukia Electricity Supply Corporation Limited, State of Assam, this court stated the law does. The courts strongly lean against any construction which tends to reduce a statute to futility. The provision of a statute must be so construed so as to make it effective and operative on the principle, and that it makes sense. It is no doubt true that the statute is absolutely vague and its language wholly inextricable and absolutely meaningless. The statute could be declared void for vagueness. This is not in judicial review by testing the law for arbitrariness or unreasonableness under Article 14, but what a court of construction dealing with the language of statute does in order to ascertain from an accord to the statute the meaning and purpose which the legislature intended for. In Manchester Ship Canal Corporation versus Manchester Racecourse Corporation, Justice Farewell said, unless the words were so absolutely senseless that I could do nothing all with them, I should be bound to find some meaning and not declare them void for uncertainty. In Fawcett Properties versus Buckingham County Council, Lord Denning, my lord, approving the victim of Judge Farewell, said, but when a statute has some meaning, even though it is obscure, or several meanings, even though there is little to choose between them, the courts have to say that the meaning the statute is to bear rather than reject it as a nullity, my lords. It is therefore the court's duty to make what it can of the statute, knowing what the statutes are meant to be operative and not inept, and that nothing short of impossibility would allow a court to declare a statute unworkable. A statute is designed to be workable An interpretation thereof by court should be to secure that object unless crucial omission of clear direction makes that end. The courts will therefore reject the construction which will defeat the plain intention of the legislature, even though there may be some execute in the language used. Reducing the legislation futility shall be avoided in a case where the intention of the legislature cannot be given effect to. The courts would accept the bolder construction for the purpose of bringing about an effective result. The courts, when rule of purposive construction is gaining momentum, should be very reluctant to hold that Parliament has achieved nothing by the language it is used when it is
No,
tolerably
Mr.
plain.
Gogoi, it's all right,
Hello.
but you see this Wildlife Protection Act
My lord,
is
that-
a penal statute.
my lord,
It has to be
no, these
interpreted
has been
strictly.
discussed. My lord, I'll place another
Oh.
judgment, my lord. One High Court judgment is Navanath Tukaram Dhaigude, my lord.
Hmm.
You copy it. It's an idea.
Neither he gives a copy, my lord, nor he gives the citation, my lord. Very difficult. We have our.
He also didn't give it, started from him only.
I gave the citation, my lord.
No. I remember that. Yes, that was agitated.
No, you said you know about this judgment. That's why you
No.
did not take copy. At first, you will
Well,
not take.
this is a criminal petition, my lord. Similar grounds are still, my lord. Navanath, this is a reported judgment 2021 SSC online, Guwahati 1962. Navanath Tukaram Dhaigude, Justice Fukon, my lord. Rumi Fukon.
So which paragraph is relevant here?
My lord. Relevance is, my lord. In this case also, my lord, the exotic species were caught, my lord. They were caught, and citing this judgments, my lord, the honorable court, my lord, rejected the contention that it does not contain, it does not come under the Wildlife Act, my lord. Para 31, my lords. 30, 31, also my lord, 32, my lord. The petitioner relied upon a judgment of Delhi High Court that the Wildlife Authority has no power, authority or jurisdiction, my lord. Para 32. My lord, there is a scheme which is called voluntary disclosure scheme. These are a scheme floated for, my lord, a specific time, wherein, my lord, person who had the custody of this kind of animals were at liberty to approach the central government and ask for the that they want their custody, and, my lord, that scheme has also been, my lord, it has expired. My lord, para 32, my lord. 31 was the, my lord, argument of the petitioner therein, my lord. It is the petitioner relied heavily on when it had been held that wildlife authorities has no jurisdiction to deal with exotic species. Paragraph 14 of the judgment is quoted where the honorable court held the central government has consciously kept the exotic animals / exotic birds out of the purview of Wildlife Protection Act 1972 by not including them in the schedule, and has thus permitted their domestic trading, possession, or captive breeding in India. It further states that exotic animals do not come under purview of the Wildlife Act, and there is no provision for Wildlife Act to issue license or permission dealing with exotic birds. The challenge to the same effort is finding that the Supreme Court summarily rejected SLP number 11659 of 2020, dated 13/10/2020, affirming the orders. Same contention are raised, my lord. The High Court allowed, the Supreme Court, my lord, also rejected that these birds, these animals doesn't come under the Wildlife Act, my lord. Now, para 32, my lord. Several decisions of other High Courts, like the judgment of Rajasthan High Court in civil writ petition number so-and-so, and the decision of the Delhi High Court in so-and-so has reiterated the same view that Wildlife Authority has no power, authority, or jurisdiction to deal with the exotic species. On the basis of the efforts of decision, the petitioner tends to submit the seized animals, animals and birds being exotic animals which are carried for internal trade, there is no need for obtaining any permission from Forest Department, or he being a declared under advisory, he is under the immunity, as he is a declared need not produce any documentation in relation to exotic life species. Now, my lord, he has 33, my lord, very disclosure scheme, my lord, I just reiterated, my lord. He has not availed this,
Not
Also-
necessary.
my lord.
Not necessary.
And though, my lord, this is a bail matter, my lord. This is the bail matter. It's and here is also, my lord, these animals. Caesar is mentioned that 5 monkeys, macaques are seized, my lord. But my lord, referring to these judgments which I have also relied upon, my lord, it was said, my lord, when my lord construing a statute, my lord, even though it doesn't come under definition of the animals, my lord, the statute has to be construed in a in a wide manner, and these animals, India being a signatory, my lord, has to bring to effect that those promises, my lord. That apart, my lords, the other, that's a subtle answer. The other argument, my lord, that interested witness, all other police witness, my lord. There's recently a Supreme Court judgment is there, my lord. Though it's an NDPS,
You have not placed it earlier.
para 7 of that, my lord. Para 7, my lords. We find no merit in this appeal. Law doesn't require only an independent witness to prove a charge, attracting the provision of the NDPS Act. As was rightly held by the courts below, there is a procedural compliance with respect to arrest, seizure, and recovery. PW3 is competent to undertake the exercise of gathering and evidence. PW7, who himself is a gazetted officer, was very much present. The recovery was also from the card. The views expressed by court for non-fulfilling of the CFCL form at the site where the arrest and recovery was made would not vitiate the case, as it constitutes a part of procedural law. And my lord, I'll go back to that handicraft judgment. Para 109 thereof. That handicraft judgment, paragraph my lord, 104, 103, 102,
Yes,
102, 103. My lord, the Supreme Court resolved to this para 97, my lord. There was that is the challenge, basic challenge, my lord, that whether ivory of African animal, African elephant, no contained in the Wildlife Act, can be construed as a part of this present legislation, my lords. 97, my lords. Can I read, my lords? The question, however, would remain as to what would happen to the property question. In our opinion, the answer must be found out by reading all the provisions in their entirety. It is now well settled that for the purpose of interpretation of a statute, the entire statute is to be read in its entirety. The purpose and object of the act must be given its full effect. Para 101, my lord. In Kehar Singh versus Delhi, my lords, during the last several years, the golden rule has been given a go by. We must now look for the intentional legislation of the purpose of the statute. Firstly, we examine the words of the statute. If the words are precise and cover the situation in hand, we do not go further. We expound those words in the natural and ordinary sense of the word. But if the words are ambiguous, uncertain, or any doubt arises from as to whether and to the terms employed, we deem it as our paramount duty to put upon language of such legislature rational meaning. We then examine every word, every section, and every provision. We examine the act as a whole. We examine the necessity which gave rise to the act. We look at the mischief which the legislature intended to redress. We look at the whole situation and not just one-to-one relation. We will not consider any provision out of the framework of the statute. We will not view the provision as abstract principles separated from the motive force behind. will consider the provisions in the circumstances to which they owe their origin, will consider the provisions to ensure coherence and consistency with the law as a whole and to avoid undesirable consequences, my lords. Para 102, my lords. A statute, my lord, in District Mining Officer versus Tata Iron and Steel, a statute is an edict of the legislature, and in construing a statute, it is necessary to seek the intention of its maker. A statute has to be construed according to the intent of them. Thus, that make it a duty of the court is to act upon the true intention of the legislature. If a statutory provision is open to more than one interpretation, the court has to choose that interpretation which represents the true intention of the legislature. This task very often raises difficulties because of various reasons, each as much as the words used may not be scientific symbols having any precise or definite meaning, and the language may be an imperfect medium to convey one's thought, or that the assembly of legislatures consisting of persons of various shades of opinion purport to convey a meaning by which may be obscure, convey meaning which may be obscure. It is impossible even for the most of the imaginative legislature to forestall exhaustively situations and circumstances that may emerge after enacting a statute where its application may be called for. Nonetheless, the function of the court is to expound and not to legislate. Legislation is a modern state. In a modern state, is actuated with some policy to curb some public evil or to effectuate some public benefit. The legislation is primarily directed to the problems before the legislature based on information derived from the past and present experiences. It may also be designed by use of general words to cover similar problems arising in future. But from the very nature of the things, it is impossible to anticipate fully the varied situation arising in future, in which the application of legislation in hand may be called, and the word chosen to communicate such indefinite reference are bound to be in many cases lacking in clarity, precision. The process of construction combines both literal and purposive.
Okay, Mr. Gogoi, okay, all right.
My lord will kindly, I won't trouble lordship further. 102, 103, 104. It
Okay, I
goes
will
to-
peruse it.
My lord, kindly peruse. My lord, my whole contention is this. My lord, though, my lord, these animals, as of today, they are under, my lord. That it doesn't fall. That is their contention. But my lord, this honorable Supreme Court also, my lord, while my lord defining the term wildlife, my lord, has given a broad interpretation. Lordship will also kindly mark section 57 of wildlife protection. Presumption to be made in certain cases. And because the learned trial judge also has, my lord, they applied these preponderance of probabilities,
My lord.
57, my lords. And that apart, my lords,
Here are, my lord, two acts. One is the old act, one is the new act.
Hmm.
So there are many developments after the coming of the new act.
Hmm.
So, my lord, we are concerned with the old act,
Hmm.
not the new one. And my lord, regarding the declaration, my lord, this is the latest judgment, my lord, of 27/03/2023 of the Supreme Court, my lord.
Hmm.
After the coming of the new act also, my lord, with declarations has to be made. That
Hmm.
was extended by Supreme Court, my lord, from 27/03/2023, 6 months, my lord.
Hmm.
I was arrested before that month. And my lord, I was tried of possessing Schedule 1 animal. I was convicted of possessing Schedule 1 animal. Now prosecution says that these are not Schedule 1 animal. And this was never their case in the trial, that yes, these are not Schedule 1 animal, but for such and such reasons, you are liable. That was also not their case, my lord, before the trial court, my lord. It should have been, what was their specific case before the trial court, that I was possessing Schedule 1 animal. It was never their specific case before the trial court that yes, these are not Schedule 1 animal, but you are covered due to such and such reason. This was not the case, my lord.
and
Okay.
finally, my lord,
Either, my lord, it has to go, it's a case of acquittal, or if they want to prove again, it has to go for retrial, no other option, my lord. But they cannot convict me, my lord, for possessing Schedule 1 animal when it is their own submission that these are not Schedule 1 animal.
Also, my lords. This section 49B is very important, my lords.
49?
49B, chapter 5A, my lords. 49A and 49B, my lords. The 49B, my lord, will see it is a subsection subject to the other provision of this act on an other specified date, no person shall, my lords. Subsection 4, a dealer in any captive animals being scheduled animal. Also, my lord, there is a declaration part also 49C. There has to be a declaration, and 49C has a subsection 49(7). No person other than a person who has been issued a certificate of ownership. Had been a case but that I possess this exotic animal, some kind of document should have been there.
Any schedule animal, my lord, these are not in schedule. That is the problem.
No, that is, I have,
Schedule, my lord, there is an act. Act has a schedule. Having possessing schedule animal is an offense, my lord. Now, my lord, whatever sections we take up, my lord, every section says schedule animals. The specific schedule is there, my lord. And if they want to go out of that, my lord, it should have been their specific case at trial, my lord, not at a stage
Okay,
of appeal.
okay, all right.
Obliged, sir.
417 is same.
My lord.
417,
Yes.
appeal number. same.
similar, I don't have that with me, but same.
Okay. Heard Mr. F. Khan, learned counsel for the appellant, and also heard Mr. D. Gogoi, learned counsel for the forest department, standing counsel for the forest department.
Oh,
Argument
my lord,
concluded, judgment result.
Jasmine was there, I couldn't give single copy.
Judgment. Next one.
Item 7 for
Hold on.
appeal.
Wait a minute.
I am obliged, my lord.
This petition number under 482 for crossing of the order at 3, and which is on page number 28. The 11th part is at 28. Is there you call for both the cases? I beg to read out the relevant part of the FIR lordship as page 28 lordship. FIR against Sri Indrajit Bora, subject lordship. The then Chief Engineer GMC regarding accumulation of disproportionate assets. Reference lordship. ACP PS case number 17/2023 under section 7A of the PCF. Sir, with reference to the subject cited above, I have the honor to inform you that during the course of investigation of the above referred case, a trap was laid at the official chamber of Sri Indrajit Bora, the then Chief Engineer GMC Guwahati, Assam, who was arrested on 22/3/2023 in a trap operation in connection with the above referred case for demanding and accepting an illegal gratification of rupees 6,000 from the informant of the case, with Sri Ajit Bora. Now, directly coming to the word subsequently, lordship, just below the address, in that same very para. Subsequently, the rented flat of the accused, Sri Indrajit Bora, was searched, and during the search, a cash amount of rupees 6,93,600 was recovered and seized in connection with the case in presence of witnesses. The arrested accused public servant could not provide satisfactory answer regarding the source of money that was recovered from his residential premises. Hence, it appears that the recovered money was accumulated through dishonest and fraudulent means and had intentionally enriched himself illicitly during the period of his office tenure. Further, it was learned during investigation that the arrested accused also has 17 accounts of HDFC Bank, Dana Small Finance Bank, Kotak Mahindra Bank, State Bank of India in his name and also in the name of his family members, in addition to his salary account in State Bank of India. During search in his residential premises at Petapara, it was found that his wife owns an Innova car and also a luxury car of Audi make. Besides these, the accused and his family members have various movable and immovable assets which are needed to be verified how he acquired such assets. Therefore, it is strongly suspected that the arrested accused person has accumulated assets disproportionate to his known sources of income using the color of his office in order to intentionally enrich himself during the period of office. Now, beg your lordship to take up page number 30, lordship. This is the approval letter from the concerned government as required by section 17A, lordship. This was
this was applied on 11/4/2023, Lordship, page 30. In the reference part, it is mentioned clearly, Lordship. It was applied on 11/4/2023. Is PC. And the approval was received on 5th September 2023. That is after a gap of 147 days, Lordship. Now I beg your Lordship to take up the proviso of 17A, Lordship. Of the PPA.
So what is the limit for granting approval?
It is, Lordship, 3 months, max to max 1 month. That too, under the circumstances when the approval authority gives a written explanation on that.
Usually it is 4 months.
Yes, my Lordship, 120 days approximately.
Hmm.
So here it is, here in our case, it is 147 days.
Hmm.
And may I read out the proviso, second proviso of the said section, Lordship? 17.
So when the approval was sought for?
Approval was sought for on 11/4/2023, Lordship, which is mentioned in page number 30,
11/4,
2023.
and when it was received?
Received on 5th September 2023. Thereafter, FIR was filed on,
5th September 23.
yes, Lordship. And FIR was filed on 15th September 2023. The present case, Lordship, 69/2023. Now, may I read out the second proviso of section 17A, Lordship?
Not necessary, that is
Okay.
established.
So as such, Lordship, if at all the investigating agency has approval today, in today's day, it is time barred, and as such, there is no constitutional background backing in behind the such approval. That being said, Lordship, the entire approval has fallen down, and if the investigating agency proceeds with the case any further, then that shall be held illegal, Lordship. In this regard, this is my humble submission. Now coming to the next part, Lordship. The next part is the Lordship. May I read out section 7, Lordship, for a while? I beg before Lordship to read it. Because of the previous case, it was filed under section name. Section 7A, Lordship.
No, which FIR you,
The present FIR, Lordship, but then to establish my case, Lordship, I just want to point out that there are two provisos in 17A. So both has a difference, and why is the difference and where is the applicable? That part I want to make it clear before this honorable court, Lordship.
no, why it is necessary?
It is necessary so as to elaborate on the first proviso of section 17A, Lordship. May I read out the first proviso of 17A before reading section 7A, Lordship? Then.
Yes.
Lordship is on 17A, the first proviso, Lordship. Provided that no such approval shall be necessary for cases involving arrest of a person. This point has to be noted, Lordship, on the spot, on the charge of accepting or attempting to accept any undue advantage for himself or for any other person. Now, this category of cases, Lordship, attracts section 7A. Violating section 7A of Lordship, violating section 7A, Lordship. Any public servant who obtains or accepts or attempts or to obtain from any person an undue advantage with the intention to perform or cause performance of a public duty improperly or dishonestly, or to forbear or cause forbearance to perform such duty either by himself or by another public servant. Or so this part, Lordship, in such cases, Lordship, no such prior approval is required, because the language itself is very much clear that in a trap case, Lordship, under this circumstance, Lordship, approval as a whole would not work, because investigating agency would put a trap and they're bound to arrest the person, the public servant, instantly, Lordship, if there are allegations in the case. But that being said, the present FIR being filed under section 13, Lordship.
Yes.
Second, section 13, Lordship, section 13B, if he intentionally enriches himself illicitly during the period of his office. Now, these kind of offences, Lordship, does not require a trap case to be held, and which is why, Lordship, the protection under section 17A is applied when a case under section 13B arises, Lordship. I beg to read out section 17A again, Lordship. Section 17A, Lordship. Inquiry or investigation of offences relatable to recommendations made or decisions taken by a public servant in discharge of official functions or duties. No police officer shall conduct any inquiry or investigation into any offence alleged to have been committed by a public servant under this act, where the alleged offence is relatable to any recommendations made or decisions taken by such public servant in discharge of his official functions or duties without the previous approval. Now, Lordship, ABC here are the concerned governments, Lordship. If required, I'll be reading it out. But then, Lordship, A, in the case of person who is or was employed at the time when the offence was alleged to have been committed in connection with the affairs of the union of that, which is Lordship, central government. B would be Lordship, state government. And C, in case of any other person of the authority competent to remove him from his office, Lordship, at the time of the offence. Now, point being that, Lordship, emphasizing on the word of on the definition of inquiry or investigation, Lordship, I beg for Lordship to take up section 2H of the CRPC, Lordship.
Yes. How this definition will help him?
Because I'm putting up the definition of investigation as such, Lordship. May I read out section 2H of the CRPC, Lordship? So, section 2H, Lordship. Investigation includes all the proceedings under this code for the collection of evidence conducted by a police officer or by any person other than a magistrate who is authorized by a magistrate in this behalf. Collection of evidence, Lordship. In my case, Lordship, search and seizure, whatever happened in connection of a section under section 13A was conducted before getting approval from the appropriate authority. In today's day, Lordship, if today they have an approval, that too it is time barred, Lordship. So my humble submission is that investigation, whatever they did during the investigation of the previous case, was infructuous at the no approval of law at the very first instance. And today's date, if they have approval, it has become time barred, Lordship.
Yes, madam.
Lordship, regarding the stay of the investigation, Lordship, there is a latest judgment, Lordship, that I produced. So it is time barred, Lordship.
No, the question is, approval was not given within the stipulated period.
That is their, Lordship.
Then what would be the consequence of not giving approval within the stipulated period? Yes, do you have any decided case law on this point?
This is the latest answer.
Lordship, I have also submitted the recent judgment from the Apex Court, Lordship, in the previous case, Lordship. By the way, it will give it 24.
It was 24. Need check. The 13 numbers.
It's not for us,
So, madam, can it be said that no prima facie case for granting stay is made out? Because admittedly approval was not granted within the stipulated period.
Yes.
Lordship, that is, Lordship, already, Lordship, there are prima facie material in the earlier one also, Lordship.
Earlier one, that's all right. That proceeding will go on.
And it is related to that, Lordship. and there are prima facie material in this lordship. Lordship may peruse the CD lordship.
CD is not available today?
If CD is there, lordship, CD is there. The volume is lordship may peruse lordship.
Heard Mr.
Ji Sahu, Lordship.
Learned counsel for the petitioner and also heard Ms. A. Begum, learned additional PP for the state respondent. Argument concluded, order reserved to you.
There is small submission, Lordship. If Lordship peruses the CD, both the search and seizure lists are same because in this present case also, it was seized in the previous case that was